Good. Okay. Today we are going to talk a little bit the work that we are doing at the global level, fighting a proposed UN cybercrime treaty. But before starting to discuss what's on the text of the treaty, I want to give a little of how we end up in with this treaty and these global negotiations. So there is already a global cybercrime treaty. It's not global, it's international. It's the Budapest Convention and has been the main existing treaty for international cooperation, like one country helping another investigate a crime in cross-border spying powers. It was finalized since 2001 and recently has been extended next year. Next, yeah. And we have been criticizing that treaty for many problems. And Budapest has become the de facto standard for many countries. So Budapest has like 64 countries, and many of the countries have already adopted many of the computer crimes that are in Budapest. However, and many countries have also used it as a model law, even if they have not ratified. However, some countries, like Russia, has objected to the Budapest Convention because citing concerns that it infringes on a sovereignty by allowing other nations to investigate a crime in their own country. That's one of the main reasons why Russia proposed a new cybercrime convention at the UN in 2017. At that moment, we thought this was not going to go forward. But in 2019, the UN General Assembly adopted a resolution that created this ad hoc committee. Okay, I do it. This ad hoc committee tasked with the job of elaborating this proposed UN Cybercrime Convention. And this proposal was put forward by Russia, Belarus, Cambodia, China, Iran, Myanmar, Nicaragua, Syria, and Venezuela. Many countries opposed it, including the United States and the EU, and with concerns that this treaty could infringe on people's freedom. Let's fast forward to 2002, and the UN just started the actual negotiations of this draft treaty, with member states submitting some proposed texts. Russia, having illegally invaded Ukraine in that moment, was considered less than fully credible on respecting sovereignty, which was his claim why the treaty, didn't work in the first place. But nevertheless, Russia got the ball rolling, and many of the proposals made it to the first negotiating text. But geopolitics is always messy. And in 2000, as the negotiation opposed, many of the countries who were originally opposed to the treaty decided to engage in the negotiations and pursuing their own agendas. While forming alliance in essential global negotiations is necessary to get consensus and move proposals forward, it could also be complicated because it could end up compromising the standards of human rights protections. Regrettably, instead of progressing towards a pro-human rights treaty, the current version of the draft, and it's called Zero Draft, which was released 2 weeks ago, it's the first negotiated draft that is on the table, is moving away from it. The Zero Draft has 5 chapters, one on criminalization, that we talk about computer access and all the coders crimes, and also a chapter on domestic surveillance, cross-border surveillance, technical assistance, and proactive measures. The draft convention has 2 articles on human rights, one Article 5 that will apply to the whole treaty, a general one, and one on safeguards that will apply only to the domestic powers. This Article 24 is very weak, not even strong enough, but even those articles, some countries want to delete them from the treaty. Interesting enough, when it comes to international cooperation, the previous draft made clear that human rights should apply also to the cross-border spying powers, the international cooperation chapter. However, that was removed. During the discussions leading to this Zero Draft, countries such as India, Russia, China, Iran, Syria, Egypt, and Tonga have even proposed to delete reference to the international human rights obligation, this Article 5, which is concerning, and even objective on the language of the limitations of domestic spying powers, making it even weaker than Budapest. So why we care about treaties? Treaties are binding upon the countries who decide to sign it, who are obliged to comply with them. Some treaty provisions compel states to adopt certain laws to implement such obligations. They use the state shall adopt domestic legislation. And some others will say a state may adopt domestic legislation. Sometimes a state can make reservations and say, oh, I can exclude from that provision only if the treaty allows it. It's not always the case. And this is problematic because when you come and have a law discussed in Congress, most of the core features of the treaty has already been negotiated. So there are little things you can do at the domestic level. Of course, you will try to find these flexibilities that you could use to get better safeguards in place or better protections for human rights or whatever you want to include in the treaty. But this is a sour, it's not always useful to have flexibility because sometimes it could be problematic for human rights. For instance, the treaty doesn't compel states to adopt mass surveillance powers, but also doesn't foreclose it, meaning that if a state, like the USA state, will use the particularity standard or the more standards to limit surveillance powers, others could decide not to do that. So that's why it's problematic to have too much flexibility. But sometimes it could be good because you can have people trying to advocate for better protections, especially when it comes to criminalization. So right now, we are the Assembly in 2001. That's a little. The General Assembly finally provided a draft convention to the treaty. There are 6 sections to negotiate. It was from March 22 until 2023. And it's supposed that the treaty will be finalized in January 2024, but we don't know yet. We will see. The upcoming negotiations is going to be in 2 weeks, August 21st, and we hope the treaty keeps negotiating. I think there are too many red lines in the treaty to be able to get a consensus, but we don't know, and so far, according to the timeline, it's going to be finalized in January. So what we are doing here? So let's discuss the chapter of criminalization. A matter of time, I won't be able to deal with everything. We are not going to. So, but the treaty is very broad, and so we don't have to time with everything. But one of the main concerns is the crimes that are in the criminalization section. Usually these are the core cybercrimes, and we call core cybercrimes, in the UN they call core cybercrimes to those who are computer access without authorization, illegal interference, misuse of devices, interference of data, interference of systems, etc., illegal interception, etc. But before, there were more than 30 crimes. So in that sense, we won. Many countries like Russia and China, but also many other, not authoritarian, but in the middle, were proposing fake news crimes and many other crimes that can criminalize speech. So that's out of the treaty. However, there always is a loophole, and this loophole is called Article 17, in which it compels states to adopt, to make a cybercrime, any other applicable cybercrime treaty that exists. Imagine there is a treaty of terrorism, of lying, smuggling, narcotics. Now they all have to turn it into cybercrime. And that's all. Making something offline and turning it into cybercrime is a problem because many of the provisions of limes, they don't have problems like criminal liability by intermediaries. They have not been fought under how these crimes will be committed, under which conditions. And so making this automatic translation could create a lot of problems. So we are asking to delete this loophole. But what is more important is that the crime have these articles of computer access without authorization that you already know maybe from the CFAA. However, what is new here is first, the older convention, the Budapest Convention, was ratified by 60 countries. So 60 countries has those crimes in their books. I don't know, many others may have adopted, but it's not the 194 countries around the world. Meaning, by adopting this treaty, and if we get consensus, all countries around the world will have these crimes. And it's not only that it's a problem, it's that it also has an article on jurisdiction, when a state can claim jurisdiction on the investigation of crime. And the real issue of this treaty is international cooperation. Once all countries have in their books this crime, they can help each other investigate a crime, and they can easily claim jurisdiction for the investigation and extradition of a crime and extradition of the person accused. So Article 22 have, you can claim jurisdiction if the offense happened with its territory. A state can claim jurisdiction if the offense involves a national, even if you are not in the territory, whether they are victims or perpetrators. Also, if the offense is planned outside but committed in their territory, or if the state is against the state itself. Let's make a case to understand this, and a simple one first. If a security researcher from country A, without authorization, accesses a database in country B, and country B has the jurisdiction because the offenses happen within its territory. But if the researcher is a national also of this country B, or target a nationals of country B can also claim jurisdiction. And even while operating from the United States, let's say, country A, country B can still claim jurisdiction in those cases. And if there is multiple countries investigating the crime, they have to coordinate, but they don't say how. And this is very problematic at the global level when you have different countries with different standards of human rights protections. So let's see a little more complex scenario. A security researcher from country A, let's say a democratic nation, identifies a vulnerability and without authorization, without rights, access a database in country B. Let's say country B is an authoritarian regime. The database, which is unknown to the researcher at that time, contains sensitive information about the dissidents from country C, which also is an authoritarian regime. So we have country A, democratic, country B and C, authoritarian, and information about dissidents from country C. The researcher's intentions are purely academic, but the implications are political and sensitive. So what would happen here? Country B would likely want to claim jurisdiction over the matter since the unauthorized access occurred in their territory. Given the nature of the laws in that country, they might paint the researcher as a spy or a foreign agent and demand extradition. Country C would also be deeply concerned as their national data was compromised. Even though the researcher has no malicious intent, the sensitive information nature means that country C would likely also claim jurisdiction over the matter, possibly painting it as an act against the state, which is also another clause in the Article 22. If the researcher travels to country C for any reason, or if country C can somehow apprehend him, country C would want to establish its own jurisdiction over the researcher. Especially if country A, imagine the United States, don't want to punish that person. Since both country B and C, that both authoritarian regimes have stakes at issue, there will be a diplomatic tussle. And when there is diplomatic issues, it gets very complicated and murky. The two authoritarian regimes might coordinate or even blame country A for supposed espionage or interference. Country A, being a democratic country, would find itself in a very difficult position. And depending on the international relationships, treaties, geopolitical strategies of that country, country A might be forced to either protect or distance themselves or even hand over the researcher to the country. So we are calling for Article 22 to also to be deleted, because once you claim jurisdiction, other laws could apply to them. And this is problematical also for the surveillance powers, because some countries' laws, for instance, when claim jurisdiction may have laws that are very draconian and have very little standards, or can create obligations on providers to localize data, among other issues, that will make easier for them to access data. So I think I will pass to Bill about, but just to make very clear, while these articles are already in the GFAA, we think that most importantly, we need to have limitations here, and we need to make sure that computer access without authorization means breaching a security measure that is done with dishonest intentions, causing harm, and that and there should be a public interest protection for the public interest. This article is not only applicable to security researchers. Many of the work of journalists sometimes involve in finding information that is very obscure on the internet, but it is public available, and if it's just using a simple tool to get access to information that is public available, that could make them a crime, and then we have all these other repercussions. The treaty itself is a treaty about international cooperation, meaning now whatever country can help the other country to investigate that crime. We are fighting for dual criminality to make sure that the crime that is being investigated is a crime in both countries, but that's not mandatory. Right now it's just optional. And even two countries who are authoritarian regimes may allow each other to help each other investigate a content-related crime, a crime that is inherently illegal under international law. Lèse-majesté, for instance, insulting the king. So they will use the whole surveillance powers to investigate a crime that is that. For us, that's providing a legal I think that the treaty, what it's doing is providing a legal basis for authoritarian regimes to rank among, to legitimize the illegal practices of international cooperation on crimes that are not worth it, or should not be subject of criminal investigation. So I pass.
Thanks very much, Katiza. As Katiza mentioned, Articles 5, which is kind of applies to the entire treaty, and Article 24, which applies to the new investigative powers with regards to human rights, the human rights limits on the new powers that are delegated to states that are signatories to the treaty. What we want to push are stringent limitations to the new powers on surveillance. And we would love to see the UN Cybercrime Treaty in general be just discarded, but if at the very least there should be stringent safeguards on human rights abuses that are possible. One thing that we want is to set time limits on investigative powers and surveillance. So if there is an investigation going on, then set strict time limits for when that cooperation will happen. Effective remedy, which is when someone is targeted for investigation and they are targeted wrongly, then they should have the ability to then in the future seek remedy, seek some kind of justice for what had happened to them. We want to require prior judicial review when a surveillance power is brought to the table. There should be in the country which is employing the surveillance technology a judicial oversight that happens prior to it actually being implemented. So, and then factual basis. For any crime that is being alleged, it has to be a paper trail for, why you think this is a crime that's being committed, and that there could be vetting on both sides, and not just arbitrary statement that this is happening by, say, an authoritarian regime forcing investigation on someone who is in the jurisdiction of a democratic society. And finally, we want the investigative country to tell the public how often these new powers were used, somewhat like a transparency report for the amount that these new powers were used, so that we know if there is massive abuse happening, say mass surveillance. So we want these strong protections to be incorporated within Article 24 on the new investigative powers. So we want these we want a new bolstered Article 5, which applies generally to the convention, and Article 24, which applies to these new surveillance powers. One of the things that's problematic throughout the treaty, the Zero Draft, is the term competent authorities, which is not defined. So in these conventions, you'll have a long text, and the terms and definitions will be in the first few articles. Article 2, in this case, defines a whole slew of terms, but not competent authorities, which appears throughout the treaty. And competent authorities could be interpreted as prosecutors or law enforcement by countries which adopt this. So we want that to be better defined and not to apply to, say, overzealous prosecutorial authorities. What should be most relevant for the DEF CON community is perhaps Article 28. So Article 28 empowers the search and seizure of stored data, allowing competent authorities to compel those with device knowledge to disclose information about how to access data on these devices. Say security researchers who know about a vulnerability in a device or network, and they are given, investigative authorities are given new powers to compel them to take part in an investigative. This is open. This is the wording is open to interpretation, but it can be interpreted as forced disclosure of security vulnerabilities to government authorities. So this is something that we at EFF feel very strongly about, and also has to do with another piece of pending international legislation, which is the EU Cyber Resilience Act, and that's another piece of legislation which may compel companies to report vulnerabilities to EU regulatory authorities when there is a vulnerability that they know of. Basically, it's trying to rein in the irresponsible companies from not doing their due diligence with regards to end devices and patching vulnerabilities. But the good actors in the space of cybersecurity are reasonably terrified of this because vulnerabilities are very justifiably so regarded as well-kept secrets in the industry, and they don't want to alert regulatory authorities to continue the spread of information about a vulnerability before, for instance, it's able to be fixed and pushed. So these are kind of it's a new push by governments to get information on vulnerabilities, both in the UN Cybercrimes Treaty and in the EU Cyber Resilience Act. So what is next? Next is the 6th session of the Cybercrime Convention, which will happen, and Khatisa will be attending in August and September. And that is when an intensive round of negotiations will happen around the text. We're trying to get these protections built into the text of the convention, and that'll be incorporated into a final draft if we can hopefully have some input on the process, although they're not obliged to listen to us in any way, shape, or form. But then in January, February of 2024 is when it'll go into effect, and there can be new signatories. But that deadline is January, February 2024, may be pushed back if there's not agreement in member states. So we're trying to stand up for users' rights and the rights of security researchers not to be criminalized in the international forum, and we hope that you will all follow this closely.
Thank you.